I would like to thank you, Mr. Commissioner, very much for being today with us, because we are in urgent need of clarification. What we need is a debate on the fundamental questions of how we got to this point and where do we want to proceed from here, starting with questioning the process by which the increased use of information technology in border controls has become the norm and a policy trend in Europe. We also need to discuss where the limits could and should be drawn for a fundamental rights perspective. Therefore, before proceeding, we have the duty to examine the fundamental rights implications of collecting, storing and using biometric data for immigration, asylum, visa processing and border control purposes, thus bridging the topics of migration and data protection. The smart border system shouldn't be put in place at any cost. We need to make sure that the system is really needed and that it will be an asset without undermining the fundamental rights of EU and non-EU citizens. I am particularly concerned in this respect about the access for law enforcement bodies. So, shouldn't we explore the possibilities first to use the existing systems before building a new one, considering both budgetary and data protection aspects? And as mentioned already by you, Mr. Commissioner, the second key point is the data retention period. The ruling of the European Court of Justice doesn't leave any room for interpretation, and we cannot ignore it. Where interferences with fundamental rights are at stake, the extent of the EU legislators' discretion may prove to be limited. And the question that remains is how can we make sure that the principles of necessity and proportionality are respected? Thank you very much.